my lords. Thankfully, the computer has unfrozen, so we should be able to make progress. In relation to the topics to finish off on, in terms of just to give you some revised headings, bearing in mind the time, just to let you know what I intend to cover this afternoon, I'm going to finish off a comparative law review analysis and pick up on the Ryan point raised by my Lord Legate. I'm then going to briefly just look at singularis and where singularis would be left if your lordships took various different courses articulated in argument. Thirdly, deal briefly with the bank's note on the juridical basis and our brief submissions on that to the extent we haven't already done so. Fourthly, questions of policy. And fifthly, again, if I have time, a brief conclusion. So those are the headings to address, which hopefully satisfies the areas that your lordships are going to be interested in. Now, in relation to the question of comparative law analysis, I gave your lordships a reference, just to finish off on New Zealand, Tyree reference, and just for your lordships' note, in case you want it, it's at page 2971. And that the landing point in New Zealand is serious or real possibility of fraud on customer. But before I go on to the other jurisdictions, I should just simply say in headline terms what we get out of the comparative law review. And there are three headline points to identify. The first is that none of them are rationalised on an agency, authority or lack of authority basis. The second is that they are rationalised on the basis of an implied term, reasonable skill and care, and substantially influenced by English jurisprudence, but also based on their own jurisprudence. And then thirdly, the landing point for each of those jurisdictions is not actual knowledge. I'll come back to the Ryan point and how Ryan is to be interpreted. But none of them, the landing point is actual knowledge. And so if your lordships were to end up at that conclusion, it would put us out of sync with all other jurisdictions that we've looked at in our comparative law analysis. So having set down that gauntlet, let's look at Australia. And in particular, the starting point is the decision in Ryan. And the question arises then in relation to Ryan, what is the point that's arrived at in Ryan? And the page reference, if you'll forgive me, I'll just dive straight into the relevant passages, is 5836. And if you could read from 5836 to 5837. Now, my Lord, having asked you to do that, if I can also ask you just to go back a little bit and I apologise, at 5835, you see the phrase that we picked up on in our written case at, starting with the paragraph in the absence of other circumstances.
What, line 17? Yeah.
Yes, please, yeah. And if your lordships have had an opportunity to digest that, I had the following submissions to make. First is if you just read the parts of 5386 to 5837, you see that the...
I'm so sorry, just before you make your submissions on
yeah.
I mean, where the judge refers to unqualified obligations being subject to a qualification, I think he's referring back in his own analysis to what he says at page 5833, lines 37 and following, where he's already said that the test to be met is the usual implied terms test, that it goes without saying. I just want to check that I've understood it correctly.
It's fair to say that I think in Carrack, Mr. Justice Brightman uses the Reigate test as a check, if not the basis for the reasoning.
But this judge uses that test in 5833, as my Lord says, doesn't
yeah, and it may well be that following that a similar approach is taken in relation to this case.
Yeah, I mean, I'm just scrolling through 5834. The judge, having set out a discussion of the principles, he then says, in the present case, it's necessary to apply those principles in new circumstances.
The only qualification I think some care is needed in terms of drawing a conclusion in that respect is the final sentence you say, in my opinion, the principles applied in those cases are good law. And that's a reference to both Selangor and Carrack Rubber. It's not immediately obvious in Selangor that the Reigate test has been applied from memory, but and Groves-Raffin will turn to shortly, which is the Canadian case or equivalent to the Quince care duty. But for present purposes, it matters not for this part of my submission that your lordship may arrive at the juridical route in one way or the other. What I'm focusing on here is the landing point aspect of the test, and I recognise that there are all sorts of different analyses one might use to arrive at that point. Ultimately, we're concerned about the landing point for my client's sake in relation to this case. And in relation to that, but you're right to draw my attention to that, and you can see it's built on those English authorities and the Canadian authority. And the short point I was going to make is if you go on and look at how it's then discussed and articulated, we have at 5835, if a reasonable banker properly applying his mind to the situation would know that the plaintiffs would not desire their orders to be carried out if there were the circumstances known to the bank. Now that, in my respectful submission, is not saying only if there is actual knowledge of fraud. What it's saying is the reasonable banker is assessing whether or not this piece of information is something that, if their customer knew about would require them to press pause. And it's an objective test, not a test based on actual knowledge of the bank.
Well, it's based on actual knowledge of circumstances, I think, isn't it? But it's then whether a reasonable banker with knowledge of those circumstances
exactly
would conclude that the customer would be bound not to.
I can see. I don't demur from that proposition. If you can see if you go on and look at the later passages, I can see how my Lord Legate has drawn a conclusion that this may be actually talking about only the circumstance where the bank has knowledge of actual fraud. But that's not actually, I don't think, what Mr. Justice Garvey is seeking to say, and it's not been how it's been read in the Australian jurisprudence since. So there are two possibilities, I think. One is that what he's saying at 5836 and the different formulations he uses in 5835 is as my Lord Legate has posed in argument. The other is that what he's actually saying is that the inquiry is this a factual circumstance which the reasonable banker would know that their customer would want to have drawn to their attention and press pause. And so it accommodates the circumstances in which the reasonable banker believes that their customer would want reasonable grounds of fraud to be drawn to their attention. It's not a test based on actual knowledge. At least that's not the only interpretation in our respectful submission. We can understand why one reading of it might lead to that, but it's not in our respectful submission what in fact is being said by Mr. Justice McGarvey in this case.
But I mean, I'm looking at the bottom of 5836.
Yeah.
He's not talking, doesn't seem to be talking about whether the customer would wish to be informed.
No.
It's a test of whether the customer would desire the cheque to be paid.
Yeah, so let's...
And again, the test in this judgment is set very high. It's not just suspicion that he might not want to.
No, I agree it's not just mere suspicion, but as we'll see in the later cases in Australia, it's not actual knowledge either. It's an assessment of, are the circumstances such that the customer would not want me to pay this money? I'm not demurring from that as a concept, but what I'm saying is that actually a proper analysis of the Australian jurisprudence is it's something which the customer would want the principal to stop, and that's not just actual knowledge of fraud. And in order to pursue that and make good that point, if we look at 5837, if you look at that, the application on the facts, at lines 39 to 43 and 44, it's an objective inquiry which doesn't simply land on actual knowledge of fraud. And in our respectful submission, that would be a misstep if the court were to either follow that or make that reading of it. If I can make good that submission by looking at some other Australian authorities which have followed it and applied it to see how they've interpreted it. So if we can next look at the decision of Meek, and that's at it starts at 5728. But the material passage is at 5784. I invite your lordships to look at paragraph 439. And 440. And then on, if I may, into the next Australian authority, I'm not taking it too quickly, to...
But the paragraphs are just quoting from the two English cases.
Yeah.
Yeah, but it's the phrase, this principle was adopted in Carrot Rubber.
I see.
What do you mean in Ryan?
And followed in Australia in Ryan. Yes, thank you. I do mean that.
Sorry, yes.
My apologies. So we can also see that's consistent with other later reading of Ryan as well. So, for example, if we look at the territory sheet metal case, which is the next case on the list, I mean, we rely on Meek as showing a recognition of fraud outside the Paradigm Agency case as well, but you can read the facts for yourself and see that. Sheet metal starts at 5972. And So it's a 2009 decision, so a little bit later again. And if we look at 6070 within the actual report or judgment,
Well, it's quite a helpful summary of Ryan.
there is, yes, starting at 1203. And if your lordships want to briefly read that. I think it's proposition 9, I think, which in particular hones in on the landing point issue. And perhaps 10 as well. And I'd also invite your lordships to read on to look at 1210 and 1212, please, at 6071. So, my lords, that's Australia, which in our respectful submission is not consistent with an actual knowledge landing point. And in fact, in our respectful submission, puts a sensible restraint or control on the principle by reference to the reasonable banker test.
Well, yeah, in paragraph 1204.9, I mean, the summary of Ryan is still that the bank has to know that. If the customer knew the circumstances known to the banker, the customer would not desire.
Absolutely. So it's a tight test in the sense that it's not a matter of equivocation on the bank's part. The banker must know that it is a circumstances that would result in the customer wanting them to stop the payment.
Just to be clear, is this a test that you're advocating as correctly stating English law as well, or are you just showing it to us for interest, for comparison?
Well, for two reasons. One, it's the same as English law, actually the landing point in my respectful submission.
So it is your submission as to what the test is in English law?
Yes. Because any rational customer who is faced with a serious possibility that they're being defrauded would not want the money paid. Next jurisdiction on the list was, I think, New Zealand. And, my lords, I think, I can't recall now, I gave you the Tyree reference for New Zealand, didn't I? And we've already looked at Westpac. Can we now look at Tandem, please? And Tandem involved a third-party fraud scenario. And if we go to the start of the decisions of 2962, so it's a first instance decision in New Zealand, and it's the 2021. And for the facts, if we look at 2963, You can see the different causes of action in play as well. And if we then go to 2972, at paragraph 37, we see the analysis of where the matter has landed in the analysis of the first instance judge in this case. Same test. And you'll see in passing that that's notwithstanding that Westpac was front and centre and referred to in the analysis. That's New Zealand. If we now look at Singapore, and here we have an appellate authority in the form of Sue and May.
Tandem, that discussion in tandem was all to do with an implied contractual duty.
Yeah. Yeah, so none of these cases rationalise this on a basis of restriction on mandate as an approach. They're all implied term duty principles. In relation to Singapore, the next jurisdiction, if we could turn up 2831. And you'll see the composition of the appellate court, and you've already been taken to this decision by my learned friend, but in particular, for our purposes, we would invite you to look at, when analysing this case in particular, you'll see at paragraphs 13 and to 15, that on the facts, it involved an authorised instruction and the law, in terms of the landing point, is at 23 to 25. 2834 for 13, and as far as the law, the discussion starts at 2836. And if you could read paragraphs 23 through to 25, please. My Lords, next jurisdiction, Canada. And so far as the equivalent, if you like, of Quince Care, we see that's a case called Groves-Raffin, which the material part of it is at 5591.
I'm sorry, I missed that page.
Groves-Raffin, page 5591. And if you could read over to 5592.
I'm sorry, when does this case date from?
The Groves-Raffin decision is 1976.
Thank you.
And it's fair to say, I should probably draw your Lordship's attention to the passage at 5592, starting where Scotia did not question. So there was no challenge made by the Canadian lawyers to those propositions, but they were accepted and have since been adopted and followed in Canada ever since. And again, it's an objective test based on an implied term analysis. If we can skip on from that to a very, very recent decision of the British Columbia Court of Appeal in Zeng. You may recall this was the case that we looked at yesterday with my learned friend, not having had the benefit of the Court of Appeal for British Columbia decision. It was only handed down a matter of days ago, and this has been provided to your Lordships loose. And I don't know if your Lordships want.
No, we have it electronically.
We have it as a supplementary
You're happy to
document,
have it as a
yes.
supplement, are you, my lords? Okay. It's paragraph 36 in particular. I was going to invite your Lordships to look at in particular, not for the articulation of the test, but for the fact that the proposition was challenged before the appellate court and rejected. You may recall yesterday, I think my learned friend sought to downplay the authority on the basis of a lack of argument on the point. And we can see the argument is taken in this appellate court, which of course is a second tier appeal.
I see in paragraph 38 that this was a case where the customer had asked the bank for advice.
I don't think so. I think the fact scenario is more that the customer was contending that there was this well-known type of fraud existing in the marketplace to do with people impersonating as agents of the Chinese embassy, and the bank knew or ought to have known about that prevalent fraud, which this customer fell into the category of.
Yeah. Well, I'm just reading. The customer was in the bank inquiring about how to carry out the transaction.
About how to carry it out, yeah. We can go back and look at the facts in more detail, but I don't think it falls into the category of one of those cases where it crossed the line between the customer seeking advice and the bank giving it, if you see what I mean. A voluntary assumption of responsibility type point in that context certainly doesn't come through in the reasoning. No, I don't think it was pleaded on that basis either, or argued on that basis. And then the additional authority I was just wanting to take you to was the recent decision in Dubai, Aegeus case. That was briefly addressed by my learned friend. In relation to the Aegeus case, if your Lordships could turn that case up, it's at 2801. And in particular, I think my Lord Sales raised a question about whether or not there was something going on in the terms of the contract in this case which might have a bearing on the analysis. And we would respectfully concur with that observation. And if you look at 2817, you see this is in the analysis in relation to the quince care duty, and the endorsement of it you see at 112 and 113. And again, it's notwithstanding the first instance decision of His Honour Judge Ruston referred to, that was distinguished on its facts. But if you go back and look at the start of the discussion, and I think this was the question that I think my Lord Sales had in mind, it's an interesting paragraph 106, which says, conclusion on the mandate case, and this is at page 2816, unless the terms of its contracts with the AGS entitle it to do so, the bank acted outside its mandate in paying out on the fraudulent payment instructions. The terms of the contracts did not entitle the bank to do so if it acted negligently, which it did. So actually, proper understanding of this case is that the negligence finding was part of the ratio, not simply overturn. And you get that if you go back and look at page 2815. In particular, paragraphs 92 and 93. So it was an unusual case in the sense that the terms made the breach of mandate argument dependent on negligence, if I can put it that way, expressly in relation to impersonation fraud. Am I going too quickly, or have your Lordship's got the point?
A little bit too quickly for me. So this is a case of impersonation fraud, is it?
Yeah, well, they basically hacked into the system and used the emails. So it's impersonation is maybe not quite the right word. It's let's just look at it, precisely the paragraph. It's in paragraph 91. It's the contractual term. We further agree that the risk of fraud, forgery, or fraudulent impersonation shall be borne by me, us. Can you see that?
Yeah.
And that's interpreted by the judge as subject to the Canadian steamships analysis that if that included negligence, it would need to have been expressly stated.
Yeah, I'm just wondering how the point arises that if you have a fraudster impersonating a customer giving a fraudulent instruction, then there are in fact no instructions. The payment hasn't been authorised.
Yes.
The bank wouldn't be entitled to debit the customer's account.
Impersonation fraud was perhaps a slightly sloppy way of describing it, in the sense that actually impersonation fraud in this context is not talking about the agent of the customer. It's talking about the fraudster.
Yes.
I think it is, though, isn't what Lord Reid says correct, that there was no authority to debit the customer's account, but the bank relied on an indemnity provision in paragraph 94, and that indemnity was held not to apply if the bank had been negligent.
Well, I'm not sure if that's quite right, because if you look at 92 to 93, you'll see that says the bank's reliance on this provision turns on the question of negligence, and the mandate basis tends to merge with the duty of care basis. So my reading of this authority is that it's probably not central to your Lordship's conclusions.
I mean, the fact in this case was a fraudster hacked into a customer's email system, purported to send an email on behalf of the customer mandating the payment or instructing a payment.
Exactly. So
there was no valid instruction from the customer.
No, there was, as between the bank and the customer. As between the bank and the customer, the mere fact that someone hacks into your system and sends the email, the bank has there's ostensible authority between you and the bank.
This rather looks as it's simply a decision on the construction of the indemnity clause.
Well, it's a question of whether or not, on the interpretation of this contract, in order to be able to establish a breach of mandate claim in the context of the contract, because of a limitation clause providing that the risk of fraud, forgery, or fraudulent impersonation is on the customer. If the customer systems are hacked and an email is sent to the bank says, well, the way that we were instructed to make this payment was in accordance with the apparent authority, and you agreed, customer, between us and you to accept the risk of that fraud. And the judge analysed that exclusion or limitation on the basis that it was subject to the analysis of not applying where there's negligence on the part of the bank. That's our reading of the case.
Paragraph 92, 4 lines from the end, in my view, the risk allocation does not exclude the bank's liability for acting outside its mandate if it's negligent in acting on a fraudulent or forged instruction.
Yes, exactly.
Yeah.
So finding of negligence was relevant to both the breach of mandate argument and the breach of duty of care basis.
Yeah. But he's not really saying a bank is liable for negligence. What he's saying is the bank is prima facie liable for paying out without the customer's instructions. And the indemnity clause that protects it against the risk of fraud is not to be construed as extending to circumstances where the bank was negligent.
I think I accept that as the primary basis for the finding.
Well, isn't that what is said in the last sentence of paragraph 93? The provision does not displace the bank's liability for payment out without authority. So the starting point is you've got no authority, you're liable.
Yeah, yes, exactly. So negligence takes you out of the contract. Yeah, I'd accept that analysis. But I think in relation to then, if you go on and look at the duty of care basis, you see that's also considered independently. So it may well be that the result of that intercourse has resulted in, again, it being obiter. But in circumstances where the judge had to go on and analyse negligence on the duty of care basis at paragraph 107 onwards, I think I must accept that as a fair reading of the case. And in relation to the duty of care basis, I think it's 158 where we get the actual ultimate conclusion, but you see that the Quince care point is considered. I've already taken you, I think, to 112 and 113 where Quince care and Philipp is referred to, and then it's 158 I was going to skip to next, which page reference for that is
1824.
2824.
Or 2824.
Thank you.
It's a first instance decision, of course, but it's a recent decision in the context of on this analysis, of course, an assumption that the payment is made within mandate.
What is the law being applied?
Quince care.
I know, but what system of law?
So it's reasonable grounds.
Sorry, is it English law? Is it the law of Dubai?
Sorry, I misunderstood your question. 2817. I'll ask my juniors to check to see if we can identify that point.
This is the International Court of Dubai.
Yes, it is.
I think it applies English law.
I think it does. Yeah.
It's set up specifically as a common law court.
I think we have some English judges, or retired English judges.
It does have British judges.
I realise that, but I don't know whether they're directly applying English law or they're applying, like a Commonwealth jurisdiction might,
Yes.
English law by analogy.
It may be a matter of it can be checked. My feeling, I have a feeling that there is a law code for the International Commercial Court of Dubai. Which defaults to English law unless there's a provision to the contrary.
Yes.
But I'm not an authority on this.
Yes,
it's a matter to be checked.
I think certainly the facility agreement, provided it was confirmed by the laws of the DIFC, and then so that gets you into the DIFC zone, if you see what I mean. But
yes.
I think you're right, and certainly it appears that it's applying English law by reference to what we can see on the face of it. We'll check that point and update your lordships on that if we find anything which is to the contrary.
But this is a case where it was the payment instruction itself that was fraudulent. It wasn't a valid instruction in which the person, the customer, was making a valid instruction in the context of an attempt to defraud him or her.
It's an obiter. That part of the decision is obiter, because if you look at paragraph 107, the judge does ask himself a question: if I am wrong, back at page 2816. So he is considering English law and doing his duty to apply it.
If I may say so, I thought my Lord's question was just on the facts.
On the facts, yes.
Yeah.
Yes, on the facts, it was a takeover of the IT system by fraudsters. But that's an interesting point in itself, isn't it? Because in the context of modern fraud in the context of people hacking people's systems, that's what happens in APP fraud. It's almost an accident whether or not it's the person who actually gives the instruction that they are the customer or not. Because, but I accept your lordship's.
My only point was, in this particular case, the facts were that
it wasn't authorised.
What had to be investigated was the validity of the instruction itself, rather than anything else.
On the facts, on the basis of the primary facts, yes. The judge then hypothecates that there is ostensible authority as between the bank and the customer for the purposes of the analysis of the quint-scale duty in the second section of the judgment.
It's a rather... I haven't read the case, but it's a very strange analysis. It's saying there's a duty of reasonable care to refrain from paying out on a fraudulent payment, where paying out on a fraudulent payment isn't going to cause loss to the customer.
Well, he could have stopped on the primary analysis, I accept that. It may be that that's the reason why this case is referred to as a surprising analysis in Chitty, which sits alongside Philipp in the Court of Appeal, which is not suggested as being surprising by Richard Hooley. Now, sorry, the point on DFIC law, I think the answer to that may be at 2804, I'm told by my juniors. But I think I've already taken your lordships to that paragraph 15. I'll move on because time is short. If we can now turn to Singularis, please, to see what the consequences are for Singularis if your lordships were to arrive at various different landing points, if I can keep using that phrase and it's not becoming tiresome on the ear. 2637, please, for Singularis. And I'm running a bit behind schedule, but I'll try and do this as quickly as I can. 150, 153 and 154, please, if you could read. the short point is that if your lordships arrive at a landing point of actual knowledge, your lordships will need to conclude that singularis was wrongly decided.
This is a sort of, if I can put it this way, a classic form of case of instruction given by agents, and the question is whether there are reasons to doubt their ostensible authority. In other words, to doubt whether they have actual authority.
Yes, but
I thought that's always been put in terms of a duty of inquiry.
No, but if your lordships adopt the analysis of going down an implied restriction on mandate and say it only kicks in when there's actual knowledge of fraud. Right,
but I mean, perhaps it goes back to the debate we were having before, where an agent comes forward with an instruction, and there are reasons to doubt that it's an instruction given within actual authority of that agent. The P.T. Satria case, Salingor and the others all recognise there's a duty to inquire. Seems to me there's sense in that, because otherwise you can't be sure, the bank can't be sure that it's acting on an instruction given with the authority of the principal.
If you're
contrast a situation that we're talking about where there's no reason to question the instruction, but you're saying the bank ought to be warning its principal that the payment may go against its principal's interests, the sort of case contemplated in Ryan. I think it's in that context that, well, certainly I was putting to you that there's a very high level of knowledge for that. The two situations seem to me to be rather different.
Well, in my respectful submission, it goes back to the earlier submissions I made then about the question of authority. None of the English law actually analyses it in the context of an inquiry as to whether or not your ostensible authority is destroyed by actual authority. There is no recognition in any of those English cases that is the approach taken. And so what your lordships would be doing two things. You'd be unsettling that settled practice in English law, which has been in existence since 1960s and 70s at least. And you would be taking away customer protection, which has been previously been recognised in that context. In our respectful submission. And if your lordships were inclined to go down that route, it's difficult for us to see how you don't end up effectively in a very similar situation to knowledge and an emasculation of the concept of the Quintscare duty, because for the reasons that I think my learned friend Mr. McElroy very pithily made in his submissions, practically the ability to try and actually fix actual knowledge for the purposes of a cause of action against the bank is not realistic in terms of the way the modern banks operate. May not even apply where they've got systems in place where there's an automatic algorithm working. So, my lords, we would respectfully submit it would cause disturbance to the settled understanding in relation to that. Can I move on to point number 3, which is response to the bank's note? And my lords, in relation to I don't know if you have it to hand in front of you, my learned friend's note. It may be useful for the purposes of these brief submissions to do so. My lords, we see paragraphs 1 and 2, and in our respectful submission, paragraphs 1 and 2 are inconsistent, since if paragraph 2 is correct, then there's no need for paragraph 1. and yet paragraph 1 is what the courts have said ever since the 1960s. As for the remaining paragraphs, the extended quince care duty as found by the Court of Appeal, it suggested the juridical basis is not identified by the Court of Appeal. That's simply wrong. Lord Justice Burst does identify the juridical basis by reference to the decision of Lord Justice Rose in Nigeria and JP Morgan, and that, of course, recognises the quince care duty as an implied incident of law, a gap filler, if you like, applying to a category of contract. Paragraph 4.1, it is simply bare assertion. Paragraph 4.2, again, in our respectful submission, is simply wrong. The analysis is there is already a term implied into the contract by section 13, and it's an aspect of that implied term assessed in a particular context of where circumstances or facts are known to the agent, which the agent knows that their principal would want them to stop the payment.
But, sorry, can I just ask you about that? I mean, if the agreed service is one to pay sort of promptly or immediately, I mean, you're not saying, are you, that that obligation could be watered down by Section 13 of the 1982 Act, so it's turned into an obligation only to pay according to exercising reasonable care?
It's an extremely unusual situation, but it's the situation where the parties have agreed both terms should apply, both that the duty of skill and care should apply, and that is in the course of the payment instruction. And it does qualify or restrict or imply a restriction, or there is a duty where those special and unusual circumstances arise, where the circumstances or facts which are known to the agent and not known to the principal would cause the agent to believe that their principal would want them to stop.
Thank you.
That is, in our respectful submission, the consistent principle applied throughout the jurisdictions we've been looking at, including this one. Now, in relation to the question, I think a term point is raised in relation to subparagraph 4, in relation to the bank's own terms. I haven't yet addressed them, so I should briefly. Putting to one side for the fact for the moment that it's not been pleaded by my learned friends as an implied restriction in their pleading, but just dealing with it on its merits. There is a factual dispute between the parties as to whether or not the terms are incorporated. And in relation to the construction contended for by the bank, that's not accepted by us. Indeed, it's contentious. In our respectful submission, and as set out in our written case, we would respectfully invite your lordships to conclude we reasonably think is equivalent or similar to reasonable grounds. I'll come back to this point and develop it shortly. But in any event, is insufficient to exclude the implied term, which is the recognised other duty in the bullet point in the terms. And we would respectfully refer you to the reasoning of Nigeria and JP Morgan Bank when approaching that issue. The fifth point is that if it was pleaded, we would of course plead reliance on the relevant provisions of UCTA and or the Consumer Rights Act, if it were to be pleaded, but hasn't yet been. And in relation to that issue, obviously, then you get into a question which is again for trial. So far as the a question then of the terms point, if I can briefly just unpack that. In relation to the terms, if we can go to 393, even if one approaches this on the basis of a different landing point in relation to the implied position under the common law, this provides that the bank has a discretion not to follow an instruction if by carrying out the instruction we might break a law, regulation, code or other duty that applies to us. Well, one might say that actually they would be obviously under an obligation to do that if they were under a duty at common law, under a quince-care type duty or similar, or however it's interpreted as an implied restriction. And then we reasonably think that a payment into or out of our account is connected to fraud or any other criminal activity, including where the funds are being obtained through deception. And then if you go over the page, while we're checking that none of the reasons above apply, now just pausing there.
I'm so sorry, where are you now?
Still at 393, but across the page.
Oh, I see, yeah.
We have to read down and then across to. While we're checking that none of the reasons above apply, there might be a delay in getting the payment to its destination. So in our respectful submission, this is a sort of plain English, customer-friendly wording, which contemplates that it's applying in circumstances where they're checking none of the reasons apply, rather than be equated to actual knowledge of fraud. And in our respectful submission, that's also supported by, if you read through to the end of that page, including the paragraph, unless the law prevents us. In effect, what's going on here is the bank is providing for the equivalent of Regulation 82.1 and the Payment Service Regulations. And that's clearly on the facts of this case. In any event, no one is suggesting that there was any particular deadline under the Payment Service Regulations in relation to these international payments. No one is suggesting it's a knockout blow in relation to the particular facts of the Phillips case, and there's an obvious reason why the Court of Appeal didn't find it necessary to explore that point, because they simply don't apply. And to the extent necessary, we adopt the submissions made by Mr. McElroy in relation to that point. But of course, that all reinforces, in my respectful submission, why this is a matter for trial. We haven't even yet got to a position in this case on knowing what the contractual terms are and which apply. If you look at the evidence that the bank's adduced, it's just a bare assertion. It's not actually giving us evidence as to incorporation. But if they do apply, then there are good grounds in our respectful submission for suggesting that what we have here is a classic situation of a bank giving itself a discretion as to whether or not it should pay, and on even the Watts world of agency analysis, a discretionary agent would have a duty to exercise reasonable skill and care in relation to that exercise. We look at Bosted's paragraph 620. Policy is probably my final heading. I suspect I'm not going to have time for conclusion, but I think Your Lordships may think that's a blessing. In relation to conclusion observations, obviously Your Lordships will take my submissions as a whole and read with written case to the extent I haven't been able to cover anything expressly in my oral submissions. But on the question of policy, if we can go to those submissions now, unless there's anything Your Lordships want to raise with me before I go to policy. So on policy, my Lords, we submit that to the extent there is any development in relation to the matter here, it's consistent with principle and policy and an incremental development. And, my lords, we've given you, I think, references to the incremental development of terms in relation to terms applied as an instance of law in our note. In the second paragraph in our note. And on the question of the factors then, in relation to relevant policy factors here, in our respectful submission, there are no policy factors or practical considerations identified by the bank or UK Finance, which is a matter of practice and practicality, distinguish this case from the agency paradigm cases, which they say militates against the recognition of a duty. There is no evidence before the court, and there is no good reason for the court to conclude that there is any significant difference. Simply because it might be said that the APP fraud involves fraud by a rogue who's not an agent of the customer does not make any practical difference to the test to be applied, as articulated by us. Three main factors to take into account. The inquiry remains on whether or not the instruction itself is a fraud on the customer, not some wider notice of fraud. Note the observations of Mrs. Justice Cockrell. Secondly, the inquiry remains focused on facts which come to the attention of the banker as a result of its ordinary communications with the customer. It's not suggesting it has to do anything which it doesn't already have to do as part of its regulatory duties and wider financial crime prevention duties. See, for example, the anti-money laundering legislation, for example, which requires in transactions above a certain financial threshold for them to carry out specific checks and due diligence in relation to payments. We, of course, are not relying on that as an independent ground for duty. What we're relying on it is as a matter of practical application consequence to the bank. It makes no difference, significant difference, in relation to the inquiries they are already performing in relation to certain categories of payment. And thirdly, the resulting inquiry does not have features which are more onerous than the agency fraud scenario, if anything less. We would say APP cases are a fortiori, are stronger. The only material potential distinguishing factor is that personal APP cases fit into a subset which is more modest than the agency quince care concept as historically seen in the agency cases. Because in the APP situation, the personal customer is not aware of any illegality, nor are any persons who would be viewed as being responsible for, unlike in the corporate or agent fraud situation. In our respectful submission, it would be a perverse conclusion in logic to conclude the bank has liability for someone who the customer has delegated functions to and bears responsibility for when they commit a fraud on the customer, but not where the person is someone who does not bear control and responsibility for. In the agency paradigm, the customer has control over that person, and it may be argued the law should be slow to conclude the bank should have a liability in those circumstances. In short, the policy factors in favour of recognising liability for fraud by a third party are stronger and fit into an easier category than the agency paradigm case. So a factor which might encourage greater caution by the courts in relation to the agency paradigm case doesn't exist in the APP case. Logically speaking, there's no difficulty in any extension if it's viewed in that way. And it would be odd if we ended up in a situation where corporate customers, in relation to risk of fraud perpetrated on them, are put in a better position than the retail. We would respectfully draw your attention to the observations of Mrs. Justice Rose in Singularis and also in the decision in the Court of Appeal. We've given you the references for it as regards this, but I think this particular passage in Mrs. Justice Rose's decision in Singularis was endorsed all the way up to the Supreme Court, and it's paragraph 17 at page 2710. Denial of the claim would have a material impact on the growing reliance on banks and other financial institutions to play an important part in reducing and uncovering financial crime and money laundering.
Your contention that questions of reasonableness, fairness and balancing of competing policy considerations are relevant to whether a term can be implied in law is highly contentious.
Well,
and insofar as you cite me in support of it in that paragraph, I don't regard any of those paragraphs as endorsing that thesis.
Well, it was endorsed, I think, probably by the Supreme Court by reference to...
There is some dicta of Lady Hale, and it starts with something, all in employment cases.
Yeah. Well, obviously that's a matter...
It's a big question, but it's certainly, it's very far from being accepted statement of the law.
So be it. Your Lordships have my point as to what we say your Lordships should adopt in relation to the approach in relation to that. But ultimately, of course, this is assuming your Lordships conclude that the reasoning of the Court of Appeal, in terms of identifying the true reason of those cases, doesn't apply. So we're looking at an extension. And we're assuming that your Lordships conclude that obviously it's an implied incident of law. If your Lordships are looking at it through the lens of just, is this a term implied in fact, you lose you probably, unless your Lordships have come up with some other different way of achieving that, you lose the benefit of the public policy factors in relation to prevention of fraud on customers. Which, in our respectful submission, you can and should preserve as a point for English law for the benefit of not only this case but future cases. The point about the end point, the consequences of your decision in relation to whether you recognise a duty or not in this case is important to have in mind. The consequences will be a narrow formulation as contended by the bank, or no duty at all, which would mean that there is no duty, there's a gap in the law for cases like Mrs. Phillips, and for many others who are the victim of APP fraud on a massive scale in this country right now. And for endorsement of this being a sensible, practical and justifiable approach by reference to principle, we've drawn your attention to the academic writings of Sandra Beeson, and if you can look in particular at pages 6496 to 6497. 6496 to 6497.
Okay.
It starts at 6492. So far as the question of regulatory scope, as I've said, we adopt the learned friend submissions in relation to that and say that your Lordship should reject the notion that there is any parliamentary intention to eliminate the power of the courts to decide whether a duty of care applies in a particular factual situation for your Lordships. It simply doesn't come close to that. I think I'll just briefly adopt the submissions already made by my learned friend in that respect, unless there's anything in particular your Lordships wanted to raise with me on those points. As regards future legislation, your Lordships, I think, have the point that at the time the Court of Appeal decision was made, there was no contemplated future legislation. Even in relation to the contemplated future legislation now, it will not provide a remedy for the circumstances of Mrs. Philipp. It will provide her and lots of people like her who make international payments with no protection. And it's rather an odd situation where we are being encouraged by the payment service regulator all do our bit to try and protect the horrific consequences of frauds and the level of frauds which are taking place in this country, to actually conclude that we're removing that protection in relation to a significant sector of people. And we all know that fraudsters are sophisticated and they evolve their methods. There's a particularly good reason why, in the context of fraud, it would be unwise to differentiate between APP fraud and the agency fraud, or conclude that the matter is best left with the legislator. The common law has the virtue of being adaptable, and provides a bedrock level of protection, which, if you look at the cases, frankly, emerge very little in the case law. We've had hardly any Quince-Care decisions over the course of the past 50 years. And in my respectful submission, there is no groundswell of problems in relation to the recognition and the continuing application of those principles and the narrow modification of it in relation to APP fraud. You have to ask yourself the question, why has APP fraud become such a big problem in modern society? There are two big reasons. One is obviously due to the development of information technology and the weaknesses that that provides in terms of trusted persons being impersonated and infecting the decision-making process. The second relates to the fact that the sophistication of fraudsters is such that they target weak and vulnerable people where there isn't protection. And if you don't have protection in relation to one area, you're not going to get industry measures targeted at that area and in order to improve it. That's as your lordships will know, the whole raison d'etre for, one of the raison d'etres for recognising the duty of care. Two final points to mention. First, the banks are better loss avoiders than the customer. My lords, the second point is they're better loss spreaders as well. And for authority for that proposition, I think we provided you with the case of Office of Fair Trading and Lloyds TSB, 2008 decision of the, in particular, it's 13 Lord Hope and paragraph 29 Lord Mance, in a context, you may recall, of an interpretation of Section 75 of the Consumer Credit Act 1974 and whether or not that should provide protection in relation to overseas credit card use. As a significant factor in that respect, the court concluded that the banks were better loss spreaders in relation to this point. So far as the point about better loss avoiders, that comes back to the point about imbalance of knowledge. Uniquely in relation to APP fraud, the customers are uniquely badly placed to recognise the risk that they are about to make the worst decision in their life. My lords, those were the policy points I had. Your lordships obviously have the written case, and I'm conscious of the time, I've slightly overrun. I think actually going back and analysing the maths, I probably did myself down by half an hour as compared by my learned friend, but that's no excuse, I'm sure, to your lordships. Can I check if there's anything from my junior team while your lordship?
Well, I have a matter to put to you, perhaps first.
Yes.
That's to ask you if we were to hold that the bank was not in breach of any obligation owed to its customer by giving effect to the instructions, what then follows in terms of the appropriate order for us to make?
Well, it depends, because obviously we would then seek to amend our case if your lordships were to recognise our case, for example, could be formulated on the basis of instead of an implied duty and implied restriction, we would want to have the opportunity to do that for obvious reasons. And of course, we could only do that until we know what your lordships have declared the law to be. And your lordships will be aware, of course, that there are certain facts which we would say would fit into the fact pattern of actual knowledge in relation to particularly what happened in terms of the police tip-off on the 19th, which is... I'm sorry? The police tip-off on the... Was it the 19th or 16th? 16th. The 16th of March tip-off. Your lordship may recall the bank was told on the 16th of March there is a fraud in relation to this account by the police.
Yes. But no more transfers were made after that.
No, but we don't know how far the existing transfers had gone down the system. So there were overseas transfers to banks in UAE. We're not even told by Barclays whether or not they had correspondent banks, where it had got to. We simply don't know. We asked for the SWIFT messages, which would put that issue to bed. They haven't disclosed them to us. We asked.
This is actually the point I had in mind when I
Yes.
put the question to you. Is there, in terms of your case, anything left?
Yes.
If we're against you on the point on which the Court of Appeal were in your favour?
Yes, is the short answer to this. There is. If you conclude that there's an only implied restriction analysis, then whether or not we have a case left in relation to the payments before, if I can put it this way, before the confirmation of the instruction on the 12th and the 13th takes place, then that aspect of our case depends on where the landing point is for the implied restriction. But if your lordships, even if your lordships are against us on that in relation to the tip-off on the 16th, there remains an unresolved factual issue on that.
As I understand it, the suggestion is that Barclays acted negligently in failing to either stop the payments reaching their destination in the Middle East, or in failing to take adequate or prompt enough steps to recover the money. Is there a case to that effect?
There is, yes. Yes, and we pleaded it out as a matter of a loss of chance, I think, because well, both on a sort of conventional basis and a loss of chance basis.
Yes. And was that, presumably, the striking out application must have been directed towards that element of the case? It
wasn't really addressed expressly, but the consequence of it is that, yes, it went. So the Court of Appeal has reversed that conclusion on the order, and so the effect of that would be appeal dismissed on the date, but obviously we would then have to narrow our pleaded case, and we would have to reformulate it as an implied restriction rather than duty.
Yes. Oh, right. And you wanted to check if there was anything else?
Yes, so hopefully that's answered the question. Thank you very much, Marines.
Thank you, Mr. Sims.
Yes, can you just give us a couple of minutes while we change the guards? Can you just hold that one? And of course, this way. Thanks. Oops, sorry, man. Get some water on it.
Yes, Mr. Goodall.
My Lords, with respect to my learned friend, he has not offered to the Court any explanation as to how this new duty for which he contends sits coherently within the overall structure of the law, or how it is consistent with the other duties operative on the bank when it receives a valid payment instruction, and nor has he offered up any coherent juridical basis for the duty. There are two ways of approaching this case, both of which support my client's argument. Either you can assess the argument by analysing the Quince line of cases on the basis of their express reasoning, and it's clear that the new duty is neither consistent with the principle nor rationale underlying those cases, all of which are focused on an internal fraud and the legitimacy of the instruction that's been received by the bank from the customer's agent. Alternatively, you can assess my learned friend's argument by analysing the substance of the Quince cases, not on the terms of the express reasoning in the Quince cases, but by reference to conventional agency principles. And those principles provide a coherent and justified explanation for what has been termed the Quince duty. In essence, it amounts to an application of the principle in cases such as East Asia that a third party cannot rely on the apparent authority of an agent if it's on inquiry as to whether the agent has authority. Now, viewing the matter from that second perspective also serves to highlight the legal incoherence of my learned friend's argument, because it offers no rationalisation for the extended quince duty for which he contends. My learned friend suggests that there's some inconsistency at the heart of the bank's case. There's not. I don't need to challenge the conventional quince care duty. All I need to do is to show you that however it is rationalised, it cannot be extended to a non-agency case. Now, in his note of yesterday, my learned friend offered up a number of different purported juridical bases for the new duty. But in truth, they all amount to the same thing, a duty to exercise skill and care. And the problem with that is twofold. First, it pays no regard to the limited scope and ambit of the reasonable skill and care duty under which the bank operates in relation to a valid payment instruction. As I showed your lordships yesterday, that duty requires skill and care in relation to the execution of the instruction. Has the bank properly ascertained the customer's instructions? Has it properly interpreted them? And has it properly acted in accordance with them? And it was clear, as we saw yesterday, that the duty is non-advisory. And my learned friend has not explained how there is room for the duty for which he contends in the light of the analysis in cases such as Redmond and Allied Irish banks. So that's the first problem. The second problem is my learned friend's argument turns the duty to exercise reasonable skill and care on its head. Rather than it being directed towards effective execution, my learned friend seeks to transmute it into a duty where the bank should not execute the instruction at all. And not only is that inconsistent with the proper scope and ambit of the duty itself, but it's also inconsistent with the primary obligation of the bank when it receives a valid payment instruction from the customer who's accounting credit, namely to execute promptly the customer's valid instructions reflecting the bank's status as the customer's debtor. Now, my learned friend's argument this morning has travelled a long way from his pleading case, and it's important, I think, not to lose sight of that. If one goes back to the particular claim at page 286, the case is put simply in terms, paragraph 56, that the bank, rather implied into the contract by various means and or in tort, is an obligation on the bank to observe reasonable skill and care in and about executing her instructions. And then 57 would constitute a breach of such duties if Barclays executed the order having failed to make such inquiries as an honest and reasonable man will make. Now, just pausing there, I don't understand 57 itself to be an allegation of duty, it's an allegation of breach. So we have 56, which is the 82 Act, tort, and implication into the contract. And we then have 58, which is, if I may say so, a butchery of quince care. And that is that we were under a duty to refrain from executing an order of Mrs. Philipp, if and for so long as it was put on inquiry. So that is my learned friend's attempt to squeeze quince care into this case, using the language of quince care, when of course it's not apposite at all on the facts. So the duties are 56 and 58. But nowhere in here is any allegation regarding custom and practice or industry practice. And indeed, even when one goes on to paragraph 61, which identifies what it is we should be doing, it's based upon what Barclays should have done. There's nothing here at all about what we should have done by reference to any industry standard or market practice and custom. The second point I would flag just as we have the pleading open, and I'll come back to it later on, this point about the 16th of March and what the bank should have done on that date, there's no separate duty pleaded in respect of that. These are the only duties pleaded, 56 and 58, execution. There's no separate duty regarding what happened subsequently, and I'll return to that in due course. Now, my own friend suggested this morning, and indeed said so again in response to my Lord Reid's question at the end, that he, quote, might have to have another look at his pleading, or I think at one stage he used the word adjust his pleading, based on where your lordships may or may not end up. And that, with respect, is simply not open to him. He has pleaded out his case as best he could in his particulars. The bank took the view that there was provided no legal foundation for a claim, and sought to strike it out or obtain summary judgment. His Honour Judge Russell agreed, and the bank then obviously failed to succeed in the subsequent appeal. But it's not open to my learned friend to have another go. He's put forward his case as best he can. He hasn't pleaded any case on actual knowledge. And that's for good reason, because he knows there's no case on actual knowledge. He can't now have another go at the case having been summarily dismissed by His Honour Judge Russell at first instance. Now, throughout much of this morning, my own friend's safe haven, I'll put it that way, in response to many of your lordship's questions, was to point at the reasonable banker. Many of the questions you asked him, he fell back on, what the industry were doing, what a reasonable banker were doing. Here's a British standard that shows what banks should have been doing. All of this is irrelevant. This is all focusing upon the question of standard of care. One has to first identify what is the duty the bank is under before one can get into the question of what is the standard of care that may or may not apply to that. And my own friend continually, throughout his submissions, elides the question of duty and standard. And we say one does not get to the question of industry, practice or standards without having identified very clearly at the outset what is the duty the bank is under.
When you say what is the duty, you mean the scope of the duty?
Yes.
Yes.
Now, my own friend said that I had not identified anywhere where this implied duty of honesty comes from. He said, I haven't identified any authority that supports that proposition. I must confess, I'm surprised that he considers it needs authority, but there's plenty of it. Let me show you first the House of Lords in HIH, which is at...
I think it's in Carrack Rubber, if I remember.
It's in Carrack Rubber too, yes, quite my lord. But HIH, tab 60, page 3957. It starts at 3948. This is a decision of the House of Lords on the question of, in an insurance context, the exclusion of the right to avoid for fraud. And at paragraph 15 in Lord Bingham's speech at page 3957, he says, just alongside the letter C, but each party will assume the honesty and good faith of the other. Absent such an assumption, they would not deal. So there's nothing at all controversial or unusual about a term being implied of honesty. And as my Lord Legate says, it also featured in Crack Rubber. We can turn that up. That's at page 2118. Alongside the letter between C and D, implied term of the contract between banker and customer, that the banker shall act honestly in good faith towards its customer, and so on. Now, I would just put down a marker there that one needs to be a bit cautious about the word in good faith. I mean, I would certainly not be suggesting that one is getting into the sort of territory that my Lord Legate has explored in other cases. That is not, I think, what Mr. Justice Brightman was saying at this point. He's talking about honesty in its classical sense, if I can put it that way. Now, the various authorities my friend has gone through this morning and this afternoon from overseas, well, one needs to be very, very careful. He picks out little bits here and there and says, hey, presto, one can join these dots together. The reasoning in some of these cases is very, very thin, and indeed, often, and this is true certainly of Ryan, it's all said to be based actually on Selingor and crack rubber. And one comes away with the question, well, where has that come from in crack rubber and Selingor? And what's perhaps notable about my learned friend's submission is he didn't actually take you to crack rubber and Selingor to explain to you how any of this provides the basis or the foundation for what he now wants to construct.
Well, what do you say about what's said in Ryan, the conclusion in Ryan, whether that is because one line of reasoning in that case doesn't rely on crack rubber. It just starts with the fact that you cannot take to extreme literalism an obligation to carry out of an agent to carry out instructions, and he postulates various situations in which if the agent handed over the money to somebody he knows is fraudster, it must be implicit in his mandate that he shouldn't do that. And then he spells out from that a general principle about where that limit comes. And that seems to me the point that, as far as I'm concerned, you need to address, because that is not dependent on an agency analysis, that aspect of things we've been talking about. It's a freestanding limit to scope of mandate point.
Yes. I mean, my Lord, I would say with respect that the reasoning in Ryan is very thin. I think from an English law perspective, one is much safer, if I can put it that way, of hanging the argument on the implied term of honesty. The problem, I think, with the approach in Ryan, and in many senses it comes back to a point that my Lord Sales mentioned. What is obviously critical from the bank's point of view is certainty and clarity. And one needs to be very clear if one is importing some non-honesty-based knowledge test as to what actually that test is and what the limits of it are. I mean, certainly the way my learned friend wanted to formulate the thing, it renders the primary obligation totally uncertain. So I think the problem with the Ryan analysis is it lacks sufficient clarity from the bank's point of view as to what it is they're supposed to do and when. That problem doesn't arise if one treats it in a conventional sense of saying, okay, the bank has an implied duty of honesty. If it's got actual knowledge that there's a fraud being perpetrated, then obviously it's very clear that they would act in breach of mandate or likely act in breach of mandate if they went ahead and paid regardless.
I don't see why it's harder or less certain than the test of whether there are reasonable grounds to believe that the agent is defrauding the customer. That's not a litmus test that you can apply. It's a judgment call. Why is it any harder to decide whether a reasonable banker would know that if the customer knew the circumstances, he would countermand the order?
Because in many senses, we're back, I think, to where we were yesterday, a submission I think that was made by UK Finance in their written case, and I think Mr. Laney touched on it orally. This concept of reasonable banker in itself introduces uncertainty. What is this notion of reasonable banker or reasonable practices across banks, when obviously there are vast differences in structure, size and approach across payment service providers generally. So the problem, I think, my Lord, is that you are introducing into the equation something which the banker faced with it may not actually be easily able to assess as to what a reasonable banker would do. If you've approached it simply as a question of honesty, it has an objective touchstone that any banker can understand. And one of the problems with, in many senses, my learned friend's whole argument is what it seeks to do, effectively, is introduce into English contract law a concept which has no place in English contract law, namely that of constructive notice. The concept of constructive notice is one of equity, and it usually has no part to play in a contract. And in fact, if we look at Bank of Scotland and A, which is at Authorities tab 58 at page 3907, the decision of the Court of Appeal, with Lord Wolfe giving the judgment. One of the points he makes, paragraph 25, is a point which I touched on actually yesterday morning when I first opened the case, which is that the relationship.
Can you give us the page?
Oh, sorry, I apologise. 3916.
Thank you.
Is that the paragraph 25, the relationship of a banker between a bank and a customer is not a fiduciary relationship. It is a commercial relationship founded in contract into which the intrusion of equitable doctrines such as constructive notice may result, in the well-known words of Lord Justice Linley in Manchester Trust, in doing infinite mischief and paralysing the trade of the country. The need for certainty in commercial transactions underpin many of the submissions which Mr. Downes made on behalf of the defendants. That's the problem, I think, of building this new construct into a commercial, contractual relationship. I mean, it will do.
Well, that goes as to whether it's actual or constructive knowledge of circumstances, and that might slim it down to circumstances actually known to the banker.
But if that's then still being tied to some notion as to what a reasonable banker might think in those circumstances, that I think is where the problem becomes more difficult. To take, for example, English law has balked generally about introducing this notion of constructive notice into contract. It has in fact done it in one limited and special circumstance, which is of undue influence in a Barclays, Bank and O'Brien scenario, where the concept has been imported, but in Royal Bank of Scotland and Ettridge, the House of Lords explained its unconventional use in that context and stressed that it should have no unsettling effect on the established principles of contract. It's perhaps just worth briefly looking at that case. That's at page 4928. And in particular, if I ask my lords to...
Page number again, sorry.
Sorry, 4928 is the start of the report, but if we could go please to 4956. And if I could ask my lords please to read, this is in Lord Nicholl's speech, paragraphs 38 to 43. and one can see at 43, Lord Nichols saying it shouldn't have an unsettling effect on established principles contract because of the way it was used in that context. And then the same flavour comes through in Lord Scott's speech, page 4991, between paragraph 142 and 147.
I mean, I can see the force of the point that you're making about the dangers of introducing standards of how a reasonable banker would behave. But I mean, suppose a situation where it's clear, well, let's say to the point of certainty to the particular banker, that not in a classic type of case, but in a case where the customer has given a payment instruction to someone, but the banker is aware of facts that, if known to the customer, the banker is sure the customer would not wish the bank to proceed with executing that instruction. One might think that that would reach the level of implication of a term in fact as between banker and customer if you've got that situation. But that goes beyond the sort of limit that you're suggesting, that the bank itself has to be involved in the dishonesty.
It also, so just to add to the question, seems to me at least an easier test to apply actually than to ask whether the bank is acting dishonestly in that situation, where you might take different views.
Yeah, and which bank employee are you looking at?
Yeah.
It's a very difficult question often.
I mean, part of the problem here lies in the point that my Lord Reid made yesterday, which is that the days of people going into their branch and having a glass of sherry with the bank manager has long since gone, and everything now, or at least a lot of things now, are largely automated. And the question then becomes, how is one approaching that sort of test that my Lord is positing in the new technological world, where the system itself just simply decides to send the payment. So I understand entirely why my Lord is positing the question he is, but I question in practice how actually it would apply, unless it's confined.
Well, that might make it easier for banks to say, well,
it might make it easier, my Lord, but it's only
this standard has not been reached in my case.
It only might make it easier in practice, but in reality, one knows that in this litigious world we live in, inventive solicitors and litigators will come forward with all sorts of claims about what the bank should have known or did know or whatever, and then the banks are facing cases trying to defend that.
Well, the normal case may be automated, but the actual case we're dealing with actually is a face-to-face case where, yes. Suppose the customer did come in, I think, after the bank had been told that yes. The police believe this to be fraud, and one might well have said, well, applying the test, would the bank employee think that the customer would say no to the payment if told that, then they should not make it. Of course, they might be wrong about that, but that would be a test they could apply.
Well, I mean, to take... I'm not talking generally now about the facts of this case, but I mean, take a scenario where, for example, there is police... there are police dealings with the bank. Now, one straight away then gets into a situation where there might be good reasons why the bank can't tell the customer under POCA, under the Process of Crime Act, because there might then be tipping off concerns.
Well, we've got that sort of situation in the case...
Shah?
No, sorry, the case about insolvency.
Yes, exactly. So Midland Bank, obviously they were concerned about breaching confidentiality. And in fact, the same issue, or a similar issue, arose in Lipkin Gorman, where Mr. Cass banked personally with Lloyds. And one of the questions was the extent to which Lloyds had knowledge about Mr. Cass's own financial position through him having been a customer of the bank. And the Court of Appeal in that instance said obviously it would have been inappropriate for them to have used confidential information about Mr. Cass's own particular circumstances. Perhaps just give you the reference for that so you've got it. It's at yes, it's at 2186 at the letter H. And I think the way my Lord Sales put his question to me, I don't think my Lord had tied it to fraud. I mean, if I may respectfully say so, your question was sort of moving on to territory where there might be questions about the prudence of the transaction. And one then straight away is running into the question about what actually is the bank's role here. It's not advisory, it's not under any duty to warn. There needs to be certainty. That's the most critical thing about all this. The bank must know exactly when and when it can't act. And as soon as you introduce any uncertainty into the relationship, that's where there are problems. I mean,
well, there isn't certainty about when somebody has apparent authority. It's not a certain test.
It's not a certain question, but it's a narrow question. It's a binary question. And that's why my own friend at one point today said, well, there's been no complaint by the bank about the quince care duty. That's because actually one can identify very easily what is the line of inquiry and what actually is the target we're trying to establish. And the answer plainly is the signatory authorised to do what he or she wants to do. Once you start moving beyond that into, well, is this something that the customer really wants to do, even though they've properly authorised it? Is it prudent? Is it in their best interests? I mean, it's a very open texture question. And you know, in a usual case, the inquiry made by the bank in a classic quince care situation is actually very easy. They phone up the company secretary or another director or whoever it might be, saying, we've got this instruction from XYZ. Is this what you want to do, what the company wants to do? So there's no, there might be uncertainty, or rather immediate uncertainty, but it's a very quick route to obtaining certainty.
Well, I've just made a payment online to send some money to Spain because a fraudster has convinced me that it's a scheme I should invest in. The bank has been told by the police that it's a fraudulent scheme. The bank gives me a call and says, by the way, the police are investigating this as a fraudulent scheme. Do you want us to go ahead or not? It's not too difficult, it seems to me, and it's fairly obvious what the answer is going to be.
Yeah, well, but if you're...
And I'd be quite grateful, probably, if they did do that. You know, if it's not their duty, then...
Ignoring for a moment questions about the Proceeds of Crime Act and tipping off and so on, and I'm assuming that there's no problems with that. I understand entirely, you know, in the way my Lord put it there. You know, one is talking very clearly about some actual knowledge on a kind of narrow basis. What I'm nervous about, though, is if one is branching the touchstone out more broadly than that, what actually is the relevant touchstone? Where is the certainty from the bank's point of view, and what are the limits of the thing? Because as soon as you start asking those sorts of questions, there's a real risk that actually the relationship is going to be fundamentally undermined, or at least drawn into doubt.
Well, it doesn't seem to have happened in Australia, as I'm told.
Well, we have the one Ryan case. I mean, one needs to be very careful, I think, about...
That test has been applied in a number of cases.
Other cases where the facts are very different, where one is talking about unauthorised transactions, or even perhaps classic or conventional quince care type scenarios.
Yeah, but Ryan's been accepted authority, I can't remember the date of it, for a long time, and the banking system hasn't seized up, I think is the point that's being put to you.
I can't, obviously, I can't speak to Australian law or banking practice, but all I would say is that there does need to be certainty around what it is that actually this restricting duty, if that's the right word, is imposing upon the banks, and in what circumstances. Yes, I mean, as Mr. Murray has pointed out, we don't actually have in the authorities bundles, and none as far as we're aware, any Australian APP fraud cases. I mean, the only APP case you've been shown is the Zen case from Canada. And in fact, let me deal with that now. The appeal decision that was handed up to you or circulated by email this morning. My own friend showed you paragraph 36. What in fact is I think the more important paragraph is 39, which I think is what this duty is hung on. And it says, as the Chamber's judge noted, there is authority for finding that a bank owes a duty of care to its customer, including a duty to inquire in the face of the bank's knowledge of a potential fraud. And then the two cases cited are Groves-Raffin and the case Semac. Now, Groves-Raffin is a conventional, I can use that word, quince care situation. It was an internal fraud case, and indeed it was cited and relied on in quince care itself by Mr. Justice Stain. So that case doesn't provide any support for any broader duty sitting outside of a conventional quince care case. The other case referenced is Semac. That's not in fact in the bundle, but a bit of Googling this morning has suggested that's got nothing at all to do with anything we're concerned with here. That was a claim by non-customers against the bank on the basis that the bank owed them a duty to ensure that the customer didn't operate its account fraudulently. And all that Semac determined was that claim itself could not be struck out, but it appears to have done it on the basis of an Anns and Merton type approach. So the foundations of even Zeng itself are very shaky. I mean, one always needs to go back and think, well, what are they relied on to get that proposition? And in truth, there's nothing here beyond conventional quince care.
Yes, I'd thought of making the point that Canadian cases on negligence have to be treated carefully because they still apply Anns.
Yes. I'm very conscious of time. Let me very briefly.
I'm very keen that you deal with this issue about is there something left over if we even.
Yes, I'll deal with that now. So the 16th of March issue, if I can call it that. So the argument here, as I understand it, is that even if the bank did not owe a duty when the payments were made on the 10th and the 13th of March, it nonetheless owed a duty on the 16th of March 2018 when the bank were notified by the police. Now, there's an issue as to what exactly the bank was told by the police on the 16th of March, but ignoring all that, we would say this alternative case remains untenable. The first point is that if the bank did not owe an earlier duty, no explanation has been provided as to how it came under a duty subsequently. And indeed, as I said earlier, in my own friend's pleaded case, there is no separate duty alleged. It's all part and parcel of the one duty said to have arisen in relation to the execution of the instructions. So that's the first point. The second point is, whatever this duty might be, or might be said to be, it cannot be the quince care duty, or indeed any variant of it, by any stretch of the imagination. Because that duty arises in relation to the execution of the instruction. It's not some ongoing duty that continues post-execution, and indeed His Honour Judge Ruston made precisely that point, the paragraph 131 of his judgment.
I may have misunderstood. I thought the point being made was that the process of execution involving correspondent banks and so on may actually extend over a period of time. So I might have misunderstood the point being made, but if so, might it not be said, depending on the test, that if the bank can stop it part way through, it may be under a duty to stop it part way through. It hasn't finished executing.
This whole argument, as I understand it, is based upon the fact that at some point, I think shortly after the instruction was given, I think in confirming it, the bank had said it might take up to 7 days for the money to hit the receiving account. And from that, then this argument's launched to say, well, actually, within 7 days, you were told by the police, and therefore some different or new duty is triggered. But
sorry, just on that, I'm not absolutely sure it would be a new duty. I mean, I appreciate you say Ryan is not the appropriate test and so on. But if Ryan gave some appropriate test, and we're dealing with a situation where the process of execution is taking place over a period of time, with the bank capable of exercising control over that process of execution over a period of time. So it's not fire the bullet out of a gun that it can't control at all. But why, if it becomes aware of facts which satisfy, let's call it the Ryan duty, would it not be under a duty to stop what it can stop?
Well, look, with respect, I think it is firing a bullet out of the gun. If once the instruction is executed, that's the end of the bank's performance obligation, and indeed that's reflected in the payment services regulations, which might be worth just looking at, which render the payment instruction irrevocable once they're received by the bank. You can see that at page 3158.
What's in my mind, Mr. Goodall, is that when one looks at the particulars of a claim, and the duties are set out begin at 286.
Yes.
And the first few paragraphs are really what one might call quince care, and this issue isn't mentioned there.
No.
But when one goes on to 61, they say, in the premises, in order to discharge its duties of reasonable skill and care as pleaded above, Barclays should have had the following policies and procedures in place. And then when you go over the page, the top of the page, D, for the purposes of stopping, or stopping isn't relevant here, but for the purposes of reversing or reclaiming monies, the subject of a potential APP fraud, where there is or should be concern that a payment may be affected by an APP fraud, take action to delay the payment. 2, communicating and or writing to the recipient bank, seeking assurances from them that the monies will be held or frozen pending any review. So one sees there something in the pleadings about this, and I think it's taken in relation to breaches. I think it must be there as well.
Well, I think it might be in C. Yes. In 63C3, I think. But
stopping is D, stopping, reversing, or reclaiming.
Yes.
Now, there's that case there. I presume you, when appearing in front of the judge, you must have sought to have that struck out.
Yes. And I in fact, didn't appear in front of the judge.
No. Well, I'm sorry. And we see in paragraph 8, he says a little about this, but I'm not sure what happened to it.
If you look at paragraph 125, my lord, of the judgment, page 259.
Yes.
So that was in play, and the judge struck the whole, or rather granted summary judgment on the whole claim.
Yes, and was that then a subject of appeal?
It was the subject of a separate ground of appeal. We'll just need to check where that...
It was, and the Court of Appeal didn't find it necessary to address the point in the light of their reasoning.
Okay.
Can you help us with the notice of appeal and the ground of appeal?
Yes, I'll just need to check. But certainly, the Court of Appeal, if you look at paragraph 9 of Lord Justice Burse's judgment,
yes,
he mentions that. The ground of appeal, perhaps Mr. Murray can dig that out.
We have included those there.
Grounds of appeal. So it looks like page...
We've got the grounds of appeal at 361.
Yes, I think they're in part 2, I think.
Ground 6. Page 363.
I'm still trying to find the page, sorry. It's
363.
363, yes, sorry. So 363 are the grounds. Yep. I mean, the grounds are incredibly confusing because they're put in so many different ways, but I think this point was ground 6, effectively. Well, I mean, I'm not sure if ground 6 merges into...
The point was acknowledged by the Court of Appeal.
I mean, it's not clear, I must say, but ground 6 at least references 16th of March.
Yes. I mean, clearly the last sentence is raising an issue about that the judge ought to have concluded that the bank should have sought to contact the banks in the UAE to ask them to stop the transfers or recall the funds.
Yes.
Well, as to assist at page 213, paragraph 9 is the Court of Appeal recognition of the point.
Yes. So it rather looks as though that ground of appeal wasn't actually dealt with.
Well, it was certainly featured in the friend skeleton argument below, in the Court of Appeal. I don't recall there being any separate or submissions on it. I think that's fair.
Yes. But then it's not the subject of any...
There's nothing, I think, in my learned friend's written case on this point.
No, it's not raised before us.
No. The point I was going to make, I'm very conscious of the time, it is...
Well, perhaps I could cut this short on this issue. I mean, I'm conscious that I've raised this because I'm wondering what the range of orders are that we should be making if we're with one of you or the other. And this obviously we need to be clear about this.
Yes.
But it may be, rather than dealing with it on your feet, you could each provide us with a short note on the issue.
Yes, Martha, certainly. I would just put a marker down here that we have not restricted my learned friend to his pleaded case, and it may well be that part of your Lordship's reasoning departs from my learned friend's pleaded case. So, source of the goose is source of the gander. And
I'm not worried about your pleadings in relation to this. It's just knowing. Obviously, there's an application for summary dismissal, so that involves dismissal of this part of your
so
case.
this has gone, and the Court of Appeal has reversed that order. So we can make the brief note to your Lordships if you prefer. But the short point is it was live in the Court of Appeal, but not necessary to be determined, and it's live before this court, as I've explained.
Yes. Well, I think it might be helpful if you were each to give us a brief note on this. And I don't know, could we say 14 days?
Just to be clear, is my Lord asking simply about for the note to cover, as it were, procedure? You don't want the party to argue substantively anything about?
No, I don't. Perhaps we'll see what your what we make of the note about procedure and see if we need to take the matter any further.
There's certainly some points on the substance I would want to make, including by reference to the payment services regulations. But I'm happy to, at the moment, to focus on procedure.
Well, the Court of Appeal didn't give it separate consideration, so they seem to have thought that it was governed by
the same point,
the
same duty.
You couldn't mention the references, but not clear to me that the judge gave it separate consideration.
There are some passages, certainly.
There are, right? Well, that's what we can look at. Yeah.
Yes, well, perhaps in that case it would be better if you were to give us at least a skeleton of what the argument is on the
yes.
As to whether this necessarily falls, if the Quintscare, if it necessarily falls with the case in relation to the instructions, if that falls.
Yes.
Or whether there is a separate rationale for supporting that part of the case.
Yes, we certainly, as I think hopefully your Lordships have gathered, that is our final end point in terms of our submissions,
yes.
and we will assist your Lordships on what your Lordships want on that. A brief note within 14 days we will endeavour to provide to you.
Yes.
The other way of doing it, but it's a matter for your Lordships, of course, would be for us to reflect on where you've ended up in terms of your reasoning, and then to make submissions after we've received it, which may be a better way in the sense that we can then know how that translates to what we had before us and make submissions on your ruling. But it's ultimately a matter for your Lordships. If you prefer it the other way around, we can assist your Lordships on that.
Order should then be made
Judge, I don't know, because we're quite satisfied by what's in the notes. If we're not, then we can say to them, look, there are other things we wish to pursue, so we'll only address. We only address what we found so far.
Yeah.
I think we can see how they put it and then make a judgment later on whatever we...
Yeah. We think it would be helpful if you were to provide us with notes at this stage, and then once we see what you're saying, we may feel it necessary to pursue the matter further.
So the note would cover both procedure and substance?
I think that would be very helpful.
Can I just I know I've made on your time enough. Can I just make two very short points?
Yeah.
One is in relation to the email that Mr. McElroy sent to the court yesterday evening, attaching the HM Treasury review and call for evidence in relation to the payment services regulations. On analysis, far from supporting my own friend's argument, the document, we would respectfully say, hinders it. What that document shows is that this is unsurprisingly, a heavily regulated area, that the payment services regulations balance the interests of banks and customers, giving effect to various complex public policies, and, perhaps most importantly, that the government is considering what reforms are necessary to better address APP fraud. And insofar as your Lordships are interested in that document, that those points are apparent from paragraphs 2, 28, 35 to 38, and 42 to 45. The final point I wanted just to flag was just so that there was, I drew a point to my Lord's attention that may be of interest to them. I know my Lords are interested in East Asia, and I wanted to pick up one point that had emerged in an exchange I had with Lord Reid yesterday morning. I had highlighted that English law was perhaps not yet settled in relation to the test to be applied when considering whether a third party could rely on the apparent authority of an agent. and that the obiter view expressed by the Privy Council in East Asia differed from that set out at least by the English Court of Appeal. Now, I may have entirely misunderstood my Lord's point, but I believe my Lord expressed the view that the lower courts would now be bound to follow East Asia.
I had in mind Woolers and Joyce.
Exactly. I dug that out overnight, and I thought I apologise entirely for, as it were, putting it before you, but I wondered whether the position was quite so straightforward following the Supreme Court's ruling in Woolers and Joyce. And as I understand that judgment, the Supreme Court was saying that, consistent with the doctrine of precedent, the decisions of the Privy Council could not be binding on any English court, or at least override any decision of English court, because the Privy Council was not a court of any part of the United Kingdom. But of course, a decision of the Privy Council would be of great weight and persuasive value. So I think the issue might be here that a first instance judge would face the unenviable prospect of, on the one hand, a binding Court of Appeal decision in the form of Quinn and CC Automotive, which is obviously referred to in East Asia and dealt with, which provides that a third party can rely on apparent authority of the agent unless it knows that the agent's lack of actual authority is dishonest or irrational or reckless as to its belief or turns a blind eye. And on the other hand, East Asia, which obviously sets the test differently, and as I understand Woolers and Joyce, the first instance judge probably would be required to follow Quinn.
Yeah.
Thank you, my Lord. Unless you have any further questions, those are. I apologise for going beyond.
No, that's entirely understandable. I thanked yesterday the interveners for their assistance. We're grateful also, of course, to the principal parties. We're very grateful to all counsel for their help. We expedited the hearing of this appeal because of its importance, and we won't take any longer than we need to. But this is a complex case, and it will take us some time.
I'm grateful.
The court will adjourn.